on behalf of OP Jindal Global University, Jindal Global Law School, and also our partner Live Law. I would like to extend a warm welcome to this Global Legal Practitioners Colloquium on the theme, the future of litigation and court practice in India and United States of America. As USA faces the maximum number of COVID cases reported, and India represents the largest democracy in the world fighting the challenge of coronavirus, how these countries respond to the current pandemic crisis will have a huge impact on the future of the world. This unprecedented crisis indeed calls for urgent attention from our healthcare systems. However, to provide order and maintain social stability within this chaos is the duty and responsibility of the legal and judicial systems. Employment risks, equal access to timely healthcare, migrant crisis, cyber frauds, domestic violence, xenophobia are only some of the issues that are emerging today, which will need the attention of our legal system. Not only must we undergo a transformation to suit the changing landscape of demands and justice, but also accept this as the redefining moment to modernize our courtrooms with the aid of technology. In times of lockdown, will courtrooms become a thing of the past? Will negotiation become the new litigation? Or we will revolutionize our legal system by embracing technology. With the rising COVID-19 cases in India and USA, will it find it all the more critical to prepare for this increasing demands on our justice system? Therefore, this legal colloquium provides us an opportunity to discuss some of the most critical issues facing the legal systems of two of the important democracies around the world, India and the US. I have a fantastic group of guests with us. Let me begin by welcoming Honorable Mr. Justice Matthew Cooper. Justice Cooper is a judge at the New York State Supreme Court. Justice Cooper is the chair of the Board of Justices of the Supreme Court, First Judicial District, and he serves on that court's Gender Fairness Committee. He's also on the executive boards of the New York State and the New York City Bar Association of Supreme Court Justice. He previously served as an active justice from 2008. He was also elected judge of the New York City Civil Court in 2001. Thank you very much, Justice Cooper, for joining us. I have with us Ms. Devika Keval Ramani, who is a partner and chair of Moses and Singer's Legal Ethics and Law Firm Practice. She also currently serves as the firm's general counsel. Devika represents law firms and attorneys in legal ethics, professional discipline, law firm risk management, lawyer licensing, and admission matters, including escrow issues. Her specialization ranges from legal ethics to dispute resolution, and she also conducts ethics and risk management audits for clients. Welcome, Devika. We have with us Honorable Ms. Justice Geeta Mittal, the Honorable Chief Justice of the High Court of Jammu and Kashmir. She is the first ever female Chief Justice of Jammu and Kashmir High Court. She is the former Chief Justice of Delhi High Court. Justice Geeta Mittal is a distinguished alumnus of the University of Delhi and also the Lady Shriram College for Women at the University of Delhi. In 2018, President Ram Nath Kovind awarded Justice Geeta Mittal with the Nari Shakti Purushkar Civilian Award for Women. She's also a distinguished jurist, somebody who has been deeply committed to academic issues as well as training and capacity building for judges across India. Thank you very much, ma'am, for joining us.
Thank you,
Last but not the least, we have with us Dr. Abhishek Manu Singhvi, a very distinguished senior advocate and also a three-term sitting member of parliament. He's a former chairman of the Parliamentary Standing Committee on Law and Justice. He was also India's youngest designated senior advocate at 34 and India's youngest appointed additional Solicitor General at the age of 37 in 1997. He's a well-known author and columnist and a very prominent media personality. He's also the senior most serving national spokesperson of the Congress Party, awarded the Global Leader for Tomorrow Award by the World Economic Forum at Davos in 1999. Welcome to all of you for joining us in this Global Legal Practitioners Colloquium. Let me begin the first question addressing Dr. Singhvi itself. Dr. Singhvi, the ultimate human cost of COVID-19 simply cannot be underestimated. With so many loss of lives as we have seen, there is no question that it has had a significant impact on the legal system. How do you imagine the landscape of the future courtroom? To what extent litigation is going to change? Do you think the court practice as we have imagined in the pre-corona world will continue in the post-corona world?
Well, these sayings are not for nothing. every cloud has a silver lining. There are blessings in disguise. And in this scourge, I think our lessons, which if we learn and imbibe them correctly, will hold us in good stead for the future. I wrote a piece in the Indian Express about a month ago. And to specifically answer your question, I believe this is not going to be COVID and normal. This is going to be COVID followed by an intermediate phase, which is semi-normal, and then the normal, which we might hopefully get to sometime. Now, it's important that we plan for the semi-normal and for the normal. And I have written there that I would love to see, even in normal times, at least 33% of cases being decided by virtual hearings. Today, what judges have not been able to achieve for 75 years, pointed arguments, no interruptions, sequential, a certain amount of time limits, discipline. This has all been a gift of COVID virtual hearings. There is absolutely no reason why we should not institutionalize it. And for that, I think we should just simply do capacity building. I find it a little sad that Indian courts, which give wide-ranging directions about monetary appropriations for COVID, running into lakhs of crores, are not provided with amounts like 10, 20, 50 crores to completely capacity build. The excuse that lawyers resist virtual hearings is largely fanciful. I think barring a infinitesimal fraction of a few percent, everybody would welcome it. And I think, therefore, simple things in India are enough to make virtual hearings a normal reality. I'm not suggesting that all of it will be, but at least plan for 33% to be like that. It's cleaner, quicker, efficient, and it's easily doable.
Thank you very much, Abhishek. Let me move to Devika in the United States and in New York. Devika, the US situation is quite extraordinary. It has already reached the place where the largest number of cases, and of course, you are in the epicenter, which is New York City. So my question to you is that, how does it change the way law firms function? Is the entire nature of commercial disputes and issues surrounding force majeure claims dominating the work that you do? Are there significant internal governance structures that are taking place in the way law firms function during this crisis? And are there lessons that you are already learning about the future?
Absolutely, Raj. This is a time that is so extraordinary for law firms and for law firm leaders and law firm management and personnel and staff. What it has done is allowed us to really take a step back and think about how could we have planned for this? And since nobody could have planned for this, it was unexpected, everyone was unprepared. How do we do this now? And firms have had to really band together and develop their own internal plans. And I have to say that bar associations like New York State Bar Association has recently issued guidance for what could be a reopening of law firms' plan. I was part of that effort, and I think that those plans are very comprehensive and provide some flexibility, and they're quite practical. But it's going to be, as you know, in New York, it's a phase-by-phase process. And there are, according to the governor, certain metrics that have to be followed. And if they are, then there may be opening over time. But we really have to wait and see. But what it's done is law firms, big and small, of different settings and different types of practices, have really had to put their thinking caps on and think about what is it that we can do remotely, which we are all doing? What does work from home really mean? And what are some of the functions that we cannot perform remotely, that once we are back in the office, we'll have the full-fledged resources of the law firm environment to operate productively. So, it's been a thinking phase, but it's also from an operational standpoint, there have been challenges, but, I think all of us have done a really great job in that regard.
Thank you so much.
Technology has played an incredibly integral role in that process.
Thank you very much, Devika. Ma'am, I want to move to Justice Geeta Mittal, ma'am. Ma'am, my question to you is that you have been a strong votary and advocate for use of technology, including e-adjudication and other measures. And I know about your work that you did in Delhi and other places before you became the Chief Justice at the Jammu and Kashmir High Court. My question to you is that to what extent e-based adjudication and technology will shape the future of dispute resolution in relation to courts? But equally important is, what's the situation in Jammu and Kashmir? The fact is, even before the current crisis, we are all familiar, there are huge challenges with regard to infrastructure in the entire state of Jammu and Kashmir. There are numerous issues relating to Wi-Fi access, and courts have also occasionally intervened. In that context, is it accurate to say that this crisis has significantly exacerbated the challenge of access to justice in the state of Jammu and Kashmir?
Let me first tell you, when I came into Jammu and into Srinagar, I joined on 11th of August 2018. And when I went into my courtroom, I was so pleasantly surprised to see a Vicom on my table. They had begun with the process of digitization, but it was extremely unstructured, because when the lawyer referred to a page 608, I saw my colleague just scrolling over page by page, and I said, why don't you use your keyboard and just type in the page? But I found there was no bookmarking. So I really had to begin from scratch. My second challenge was lack of judicial capacity. We were only about 7 judges to be divided between 2 wings, Jammu and Srinagar. And often I was faced with a situation where I had only 1 judge willing to hear a matter which had to go before 2 judges. So I was constituting benches with 1 judge in Jammu and the other in Srinagar, even in 2018, using technology. No matter what be the 2G or the 4G availability, but we have done very well. We have had continuously sittings of judges with 1 judge in either city. It's not even within the same city. Now with this, the advent of COVID, the first challenge, Raj, I must tell you that as a Chief Justice who has to run a court and ensure access to justice to the common man, was in ensuring that courts ran. And I was very reluctant to shut down courts. I kept them going despite a lot of objections till almost the last minute. I had no choice but to shut it down when the lockdown came, because my staff wouldn't have been able to travel the roads, get public transport, litigants wouldn't have been able to reach, and lawyers would not have been able to come to court. So that was the point when I had to say all non-urgent filing shut down, only urgent matters to be mentioned, and we lay out a string of directions to the lawyers and the litigants of e-filing, made it very, very informal. And we laid out the whole structure for urgent hearings, which we have been doing using the e-mode. Now, yes, you're right, there are a lot of challenges. But, I took suo moto cognizance of the fact that a lot of our students were stuck in Iran and were students from Jammu and Kashmir who were not being able to get back. And I received a lot of emails. So I took suo moto cognizance and registered a public interest litigation in which we started hearing. Now, when I began with the hearings, I found that another writ petition had been filed. I'm currently sitting in Jammu. Another writ petition had been filed in Srinagar. I'll just tell you about the challenges which a judge can face, even in one city. So I combined that writ petition here, and now I had to hear lawyers and petition parties in person in Srinagar as well as in Jammu. So on any particular day of hearing, I have at least 15 parties in the matter. So I have about 8 people on the screen before me, and then all the others who have difficulties in hearing are joined either by video call or WhatsApp call or on a landline. So I've had to innovate. So, but we've done well, very well in Jammu and Kashmir. And my other brother and sister judges, I have one more sister judge here now, who we have been hearing matters on phone calls, etc. So we've done pretty well so far as innovation is concerned. But long term, as was pointed out by Manu, I want to bring in a very important point, and I hope you'll take it further during the course of your discussions during this time. I spoke to judge friends all over the world, especially before coming here and while I was running the court. I spoke to Judge Robin Tuckman in Sydney and asked her what was she doing. And she told me she was going to court because courts justice delivery had been marked as an essential service. So courts were running in Australia. I spoke to Judge Navanitam Pillai, a former UN Human Rights Commissioner, and she was of the firm view that courts have to be available even during war. You have to answer justice related issues, human right related issues. I spoke to Judge Binta Nyoko in Nigeria, a federal judge, and she said, oh, they were just trying to get into the virtual court system with the rudimentary, knowledge and facilities available to them.
Very good,
Within
ma'am.
Jammu and Kashmir, Raj, just one quick question, a quick point I want to flag is that we are all talking of virtual courts in India and countries like us at the constitutional level. We are talking of virtualization of Supreme Court of India, we're talking of high courts, but we really need to talk of the trial courts. That's where justice has to be delivered. And that's where the common man and woman approaches first for getting justice. And that's where there is a huge infrastructure deficit.
Thank you, ma'am. That's a very valid point. In fact, elsewhere we discussed about the importance of why, let's say, legal services and access to justice is not declared as an essential service in which, like healthcare workers, hospitals, courts should be functioning in some form. All right, let me move to Honorable Justice Matthew Cooper. Matthew, from where you're sitting, I can imagine the issues that you're facing is slightly different, but I want you to quickly reflect on the same question: to what extent e-based adjudication and technology is going to be used in courts as we speak, but to what extent this is going to become the norm for the future. And an equally important issue is what Justice Mittal talked about: how is access to justice seen as an essential service when it comes to the institutions of justice delivery and other mechanisms that are in place in New York?
Thank you, Raj. And it is, to put this in context, this is the very first webinar I've ever done, let alone a webinar where two of us are in New York and three of you are in India. It's something that's almost unthinkable. And that's kind of what this situation, I think the words I heard were unprecedented, unimaginable. It clearly is. I've been a judge for 20 years. I was a judge back when America was attacked on 9/11. The court system closed for, I think, about a week. We had a superstorm Sandy, court closed for about a week. We are now closed for 2 months. This is something as unprecedented as ever been. But to my amazement, and I'm somebody who did not grow up with technology, I'm above the age of where I grew up with an iPhone and grew up with an iPad. Those were some things that came later in life. I am just astounded at what we can do technologically. But I do recognize there are certain limitations now. I think similar to what Geeta said, appellate cases certainly lend themselves incredibly well to remote hearings, to remote argument, whereas the typical everyday trial case may not lend itself as well. But seeing what I see now, I can probably, we all can predict within the next couple of years, certainly within the next 10 years, things will be so advanced that almost anything could be done but remotely and by virtually. The question I think really becomes is, do we also want to do that? Do we want to move to a system where people don't congregate in a courthouse? Do we want to move to a system where people are don't have the interaction, the collegiality, and the common civic experience of coming to courts? And that will be a big issue that we're going to have to confront in the court system, because this has been a success in many ways. The courts are, especially from my own perspective in New York State, the court system is managing still to deliver services in its own way. And it opens a brave, I think it's similar to what Dr. Singhvi said, it has been an opening. It's been an eye-opening experience because now we're aware of what we can do remotely. But I think there's a big question as to Do we really want to do that, to fundamentally change the system? And then, Rajman, you talked about access to justice. Yes, this remote system works well, probably for people who have the access, for firms, for lawyers, for people who have the equipment, have the know-how. But there's how many people are we leaving out who would normally just come to court seeking redress, who aren't able to do that? I know in New York, we've left the courts open to the extent of letting people come in, and especially self-represented people come in and file papers on their own, which then get transmitted electronically, because it would be difficult for them to do it otherwise. But there's some big philosophical questions. What type of court system do we want now that we can envision a court system that could be technically remote and virtual?
Thank you so much, Matthew, for that. Well, for all the viewers, as I told you before, there are over 4,000 people who have registered for this program, and a lot of them are viewing. I invite them to pass in their questions in the comment section of YouTube, and I'll take up those questions as we come to the end of this program. So we will answer those questions. Let's go to Abhishek. Abhishek, you heard our judges from both India and from New York speaking about access. So I know you wrote an important article which focuses on issues surrounding commercial disputes as well. So two things I would like you to reflect on. One is that, is this a defining moment for us to focus on democratization of technology, whereby all courts in India, regardless of whichever level they are, we invest significant resources and upgrade our court system? And second is, to what extent force majeure claims are going to redefine the commercial environment and dispute resolution mechanisms in law?
Thank you, Raj. Great people do think alike. You've used the word which I wanted to use, democratization. That's the crucial word. In India especially, as Justice Mittal also mentioned, in India, we don't need very high-fangled, extremely cutting-edge, kind of things. We need the basics, and more than that, we need organization of the basics. The basics are already here. Now, first, you must remember that India is not merely an urban-rural divide. There's a huge area out there which is rurban, a new word coined, I think, especially for India, which is more urban and less rural, but between the two. And barring the very remote spots of India today, mobile penetration is extremely high. Connectivities can be easily improved. And at least at district courts, there is absolutely no excuse for not having good connectivity, good lawyering through these techniques. I think it's only a question of getting it together. We've been talking for a long time. We have innumerable committees. We have the National Grid Plan. We have Supreme Court initiatives. But it's a question of doing the same thing uniformly across the country. And you require basics. You require systems of filing. You require systems of being able to access, whether by VIDYO video or by WebEx. But I'm not in agreement with the lack of uniformity. Even in Delhi, the Supreme Court uses one system, the Delhi High Court uses another system, and sometimes one is superior, the other is not superior. I think there is need to make it simple, and simply providing some monetary funding in a proper organized manner. In fact, having not lawyers and judges, but young professionals setting it up for you who are much better at it. So we must do it. And I think the base is already there in large towns, in medium towns. It's the rural areas which require it. About force majeure, I want to say that the common law does not have the romanticized version of force majeure, which we tend to have acquired during COVID. The common law is rather strict about force majeure. And I spoke recently on and did some research on the subject, and I was astonished at the very high thresholds prescribed by common law. And I think this is across England, US, and India, as to when you can invoke force majeure as a governing clause. It's much better if the law provides for it. The second best is if the contract, and if lawyers were soothsayers and prophets, if they could anticipate and the contractual clause was all encompassing. In the absence of those two, the common law has, as recently, interestingly in India, in 2017, a Supreme Court judgment which harkens back to a 1962 House of Lords, where the Suez War led one of the parties to say, look, I can't possibly supply, the Suez Canal is closed. This is too onerous, the price is increased manifold. Court said, tough luck. You go down the Cape of Good Hope and reach England that way. Mere price and onerousness is not enough, which is a romanticized version we have of force majeure during COVID. So I think possibly COVID itself will change judicial approaches to force majeure. But today, the best bet is either a Singapore model law, which is excellent in terms of being specific, certain, and categorical on a lot of COVID issues, or the contractual drafting, which, as in the old days, arbitration clauses were sloppy and weak. And over time, lessons learned from litigation were that they become much more precise. Similarly, I'm sure force majeure clauses will become precise. Otherwise, if you go by simple common law, the dice is loaded against the person who invokes force majeure.
Thank you very much, Abhishek. I want to take the same question to Devika as well. Devika, in slightly altered way, in the US and in New York, there is very strong talk about bringing the country into normalcy, bringing states into normalcy, bringing businesses into normalcy. So when we come back to that normalcy that we are talking about, a lot of damage that the lockdown and the impact on the business will remain. Do you see this as a huge opportunity for lawyers and litigating lawyers in particular to look at dispute resolution mechanism? Does it mean that the firm structure of practice in priority areas are going to change, that certain types of litigation and dispute resolution problems will have a stronger, let's say, representation in your practice?
It's an interesting question. Given the cycles of the global economy, which has rippling effects everywhere, it's either the corporate sector in the practice of law that is being successful, that is busy, or it's the other side of practice, which is bankruptcy, protecting creditors' rights. This is an interesting time. We have to wait and see. But I think that there's going to emerge sort of a whole new line, clearly, of cases, but also a lot of transactional lawyers, a lot of litigation lawyers who are in real estate practice, in corporate practice, are going to look at this situation, which they were completely unprepared for, and go back and tinker with contracts and how they negotiate deals, and kind of apply a new way of thinking about issues in advance. As lawyers, we're always looking at the worst case scenario. Transactional lawyers are always drafting contracts and key clauses with the hopes that their clients don't have to take matters into litigation, and that they'll be able to avoid disputes, and that the language in the contracts is clear and unambiguous. So I think that this crisis is in many ways is reshaping and perhaps redefining how lawyers approach their different practices, and perhaps even new sub-practices might emerge from this. And I think they're already beginning to across the world, especially in the US.
Well, thank you very much, Devika. Ma'am, let me quickly move to where you are, Justice Geeta Mittal. Ma'am, one of the things that a crisis does is it ends up having focus on the issues that are, let's say, easily visible for people, and people who are at the margins are most of the time left out. And the goal of institutions, including judiciary, is expected to be to keep those people in the margins, even remain focused during these extraordinary difficult times. So my question to you is, to what extent, let's say, Indian courts, Indian judicial system need to have or could have acted better when it comes to dealing with incarceration, the situation with regard to under trial prisoners across Indian jails? While there have been some interventions, but these interventions have not been uniform across India. What do you think the courts should and can do when it comes to dealing with jail occupancy, particularly with regard to under trials?
No, here I think, Raj, the Supreme Court reacted very promptly, and they directed formation of a committee across in all the states and union territories, which was directed to take a review of all the prisoners within the states and the union territories. And I personally know, because we have been monitoring the situation in Jammu and Kashmir, that the committees have been effective. Additionally, the courts have been monitoring what is the status of the prisoners in the within their jurisdictions. For instance, in Jammu and Kashmir, we have been calling for reports from the Director General Prisons. Apart from decongesting prisons, also the measures which they have taken to ensure the contain the spread of the COVID-19 infection in the jails, the medical facilities, the health of the prisoners, etc., is being closely monitored by a lot of the high courts, including the Jammu and Kashmir High Court, and we've had good reports. There's only one instance where of prisoners being infected, which has come out. I saw it in the paper only today. That was in the Agra jail. But other than that, the Indian prisons have been, despite the crowding and despite the large number of under trial prisoners who still continue to be detained in the prisons for because they don't fall within the criteria as has been mandated by the Supreme Court. In fact, the Supreme Court clearly laid down the basis on which the decongestion of prisons would take place. And prisons have taken some very effective measures. For instance, they prohibited visitation by outsiders. They've resorted to e-mulakats or e-visitation. They've made liberalized the use of phone facilities to the prisoners to interact and ensure the depression and etc. Those kind of psychological illnesses don't reach the prisoners. And very active measures are being taken down, and prisons are reacting very sensitively to the COVID-19 situation.
Thank you so much, ma'am. That was very useful. Matthew, I want to ask the same question to you, because I have seen a number of reports. In any case, even during pre-COVID times, United States is known for for a very strong, a sense of wanting to put people in jails. The data shows that a large number of people are continuously incarcerated. Has COVID-19 changed the public policy imagination of people, particularly institutional responses, that this can create further vulnerability among an already vulnerable populace within the prisons?
Raj, I guess, unfortunately, I can't give the same response that Geeta has given in terms of the Indian penal system. Certainly in New York State, where Devika and I are, the prisons are looked at as an incubation area, a breeding ground for COVID-19. So there has been a strong outcry that people who have committed nonviolent crimes, people who aren't going to be a threat to society, need to be released. And there have been lawsuits. That's one of the reasons why courts are essential. Federal courts have been handling many of these cases and have been finding that people need to be released. One of the problems I see is that if you read news reports and you hear, high-level white-collar criminals seem to be the people who then are sent for home confinement so as not to be subject to COVID-19. And I'm concerned that there'll be a two-tier system of doing this. People, largely not minorities, largely well-to-do, will be released from prison for humanitarian reasons, whereas we keep keeping the rest of the people who aren't so lucky. And that's something that needs to be addressed, that releasing people from overcrowded prisons, because it subjects everybody ultimately to COVID-19, not just the prisoners, but the people who will then be infected when they're released. That's a priority, but it has to be done fairly, and not just a small segment of the population should need to benefit from that. I think Devika had used the term, this is a time for law firms and the judicial system to reshape and redefine. That is something that is going to hopefully move forward and continue in terms of incarcerating people. Just one little personal note. I have a case where I'm deciding, I hear criminal cases as an appellate judge, but most of my cases are trial cases, and most of those cases involve domestic relations, matrimonial, divorce, family court. I have a case where somebody is in blatant contempt of court for having failed to have done certain things under an order that I rendered. Normally, the remedy would be to incarcerate that person 30 days, 60 days for that transgression, because it's the way of enforcing the system, enforcing the order, and especially in a case when you have a recalcitrant party. But that's something I would never consider doing now. Why would I put somebody in jail who's not a threat to society? It may be a problem in my case and a problem to the other party and a problem to the children, but why would I put a person in jail to face exposure? So it's a different world. As we said, as we've all been saying, it is so radically different than what existed pre-COVID-19.
Well, thank you, Matthew, for your progressive views and your deeper commitment to civil liberties at this hour. Let me take this question to Abhishek as well. But before I do that, for all the viewers who are watching this program, feel free to send in your questions in the comment sections of YouTube. We will have a Q&A session shortly beginning, but please add in the questions. Abhishek, I know you might want to respond to that, but I also want you to talk a bit about the next part of what we want to carry forward this discussion, is that the situation with regard to migrant workers. One of the tragic work is that while the government of India has responded quite impressively in responding at the right time and to have the lockdown, which has, I believe, culminated in relatively lesser number of cases and lesser number of deaths as well. Having said that, the marginalized and the vulnerable in the form of migrant workers, is it even fair to say that the legal system, and I dare say the judicial system, has failed the Indian migrant workers?
I think that's an absolutely fair comment. And before I answer it, let me just take 30 seconds on incarceration without taking your time. I think this point which Judge Hooper made about a iniquitous discriminatory application of such standards for the poor versus the not so poor is an extremely important aspect. In India, the real scourge is a large number of people who have bail, repeat, have bail, but cannot furnish requisite bail bonds, not being released. Now, I know we've passed several orders, but you will still have them languishing. I think these are small things which we must immediately rectify. Surety is not being given, that is, by people. And even when the directions are given to release them on their own bonds, it is not implemented for want of all kinds of procedural and bureaucratic hassles. Second, we have not experimented in sufficient numbers with open jails. We have a few which are, by the way, working excellently. But had we got more open jails in capacity terms today, we would have been able to see their tremendous use in COVID times. And third, I think we have also not done what the Americans, not in New York necessarily, but elsewhere have done rather well, experiment with anklets and GPS, and which should be applied across the board without an income discrimination. To have people less than 5 years, less than 7 years offenses released and not necessarily kept in bail with full monitoring under trial. That is as far as incarceration is concerned. Coming, I think, to probably the single most important question. Your comment is absolutely right, but I think that comment applies, and I don't think it's entirely fair to blame the judiciary. The judiciary is culpable, but by the very nature of the migrants' problem, their approach, their remedial effect is limited. You have to squarely blame governmental authorities, and I certainly am not talking politics. Starting with the central government, the back of the envelope calculation is 7,500 rupees in the direct pockets of migrants with a total bill of 1 lakh crores. I'm sorry for our American friends, they may have to do some conversions. but 1 lakh crores is the total bill for that, which is not much at all. Otherwise, the lasting terrible images of COVID, everything else about COVID is manageable, but the lasting terrible visuals of COVID will remain for 100 years, is what is happening to our migrants on the roads. And the second thing is that even from our purely selfish self-interest, which is why now the elites in the big cities are remembering migrants, who are not going to come back as your domestic servants, as your cheaper labor, as your assistants. Even from that point of view, had the central government provided timely, direct monetary cash assistance, today cash is king. And secondly, had it reimbursed state governments in time for clothing and feeding them. You know, today what has happened is the lack of these funds has forced migrants back en masse, which with those distressing scenes. And today there is a documented surge in COVID cases because of that movement. And in a democracy, I cannot prevent you from moving, which is what the Supreme Court said yesterday. We are helpless. We can't stop them from moving. But the cause of that movement has not been addressed sufficiently. So A, central government direct assistance, B, reimbursement to state governments, which have just scrounged around and did what they can. I think in all, the migrants, India has failed migrants, not the judiciary. The judiciary has partially failed them, but the judiciary really doesn't have either the manpower or the resources to manage it. But India has certainly failed migrants.
Thank you so much, Abhishek. We will come back to it. This issue requires some more discussion as well. Let me take the next part of it to Devika. Devika, I know that you work in the fields of ethics and professional responsibility. Now, one of the things that is going to happen is to what extent healthcare professionals and patient care in hospitals should be provided with legal immunity and liability protection during this time. And what ought to be the protection that need to be given for the frontline people in this COVID crisis? And how does professional ethics and professional responsibility of a lawyer comes into, or bears into question during these times?
Raj, our frontline healthcare workers are truly our unsung heroes in this battle against COVID-19. They are working under extreme pressure. They're extremely overworked. They're stressed. And we have to find ways to shield them from claims. These could be claims that they negligently treated patients and other claims. The important thing is to make sure that our frontline workers do not back away from their work, which is so important to our communities because of the fear of threat of litigation. And these things have a practical effect in many ways. Many of our frontline healthcare workers may be homeowners. And if they have tenants who cannot pay their rent, nurses and emergency medical technicians and other healthcare workers may be facing foreclosure actions with regard to their homes. So these are all rippling effects that we have to think about. Turning to some of the ethical issues here, the legal profession, as we've known it, this is a long-standing commitment that our legal profession has to duty and to commitment to public service and to social justice. Lawyers are the vanguard of the Constitution. We have a professional duty to serve the needs of our society. We've been talking a little bit about 9/11, and there were lawyer volunteers who were flooding the gates of bar associations and professional service organizations and public interest organizations to do pro bono legal work and to help victims and survivors. Now, those same lawyers and law students need to line up, but remotely, to provide healthcare workers with all the help that they need. They might be needing help preparing life planning documents, for example. So as lawyers, we play such an important role in society, in advocacy, in bringing about legal reform and legal change and access to fair administration of justice. this is emergency ethics. We're all performing our duties, serving our clients, helping our communities. But only the fact is that these duties and obligations we have as lawyers are heightened in the times of crisis. And keep in mind that while many laws and administrative orders are in place and regulations have relaxed and suspended and paused certain requirements, our ethical obligations remain unchanged. And I do want to mention one thing that Mahatma Gandhi had said. He said that there is a higher court than the court of justice, and that is the court of conscience. It supersedes all other courts. He also said, and I have to mention this second quote, that the profession of law is a means to enthrone justice, not entangle justice in the net of the law.
Thank you so much. Those are indeed great words of wisdom, but also it pauses us for a moment to think about to what extent our legal systems are prepared. For all the speakers in today's session, I have over 200 questions already, 45 minutes into the program. So I will warn you that we will be coming back to it. Ma'am, quick question to you. In pre-COVID times, our courts have been, quite prompt in responding to issues surrounding, let's say, social injustice, issues surrounding abuse of power. They've not been reluctant to pass orders against government agencies. And that's been the norm. And with varying degrees of effectiveness, our courts have done it very well. And it's quite natural, almost both people and all institutions during crisis, they need to be seen to be supporting the government, because in a crisis, you don't want to, create more challenges to government. But do you think courts have still a larger responsibility to protect the Constitution and constitutional values, even if it means that it has to go against the government?
Absolutely, Raj. There's no question about that. We have to ensure that the values underlying the Constitution, the fundamental rights, the human rights of the people are assured at any cost. And let me tell you that my experience in Jammu and Kashmir has been extremely positive. For instance, I had highlighted the issue of domestic violence. You see, the UN Secretary General had been talking about it, and it was of great agitation to me. So not only violence, domestic violence, but also elderly abuse, child violence, violence against transgenders, a very marginalized group. I had passed an order and I got a phenomenal response within 3 days. The government had released funds, they had earmarked beds and safe spaces for victims who had to be needed, victims of domestic violence. They had identified the first line, who could be approached. They had identified Anganwadi workers. For our friends from overseas, Anganwadi workers are like nursing assistants. They run small creches for small babies in the community. And there are thousands and thousands of them all over the state. They had identified these women and workers who could be approached by any victim of this kind of violence. I have passed an order with regard to animal care or keeping open veterinary clinics, and I'm awaiting a report for them, and I'm fairly hopeful that it will be very positive. I had passed an order for ensuring help to dependents of the COVID warriors, our healthcare professionals, the police personnel. They also must be having dependents who need assistance. They must be having children who are having mental health issues or otherwise disability issues, or having parents who need medical assistance. So unless we are able to give that kind of a backup to a doctor who is addressing COVID-19 issues, that doctor will not be able to give their 100%. So we've got an entire network working. So courts can work very proactively and ensure not only the rights of the citizens, the common man on the street, but also the other rights, ensure the same rights to the people who are engaged in this COVID-19 crisis. Also, we've seen that courts all over the country, for instance, there's a legal issue I'll point out from a criminal case which has come up before the Madras High Court. We have this provision of statutory bail. Matthew may be aware of that. You must be having it in New York also. If you don't complete the investigation and the person is in prison within a specified period of time, then the person is entitled, and you don't file the charge sheet, the person gets what is called a statutory bail. So we have similar provisions here. And the legal question which was urged was that the investigation had not been completed. The statutory prescribed period came to an end within the COVID-19 lockdown period. The state took up a plea that no, we were helpless. The investigation could not be done because of the lockdown. The officer could not have been exposed to the risk of the infection. The court was extremely liberal and rejected the state argument and held that the person was entitled. I'm told that another single judge of the Madras High Court has taken a contrary view, and the matter has gone to the division bench for resolving legal issues. But yes, the constitutional courts have the basic and essential duty of ensuring the constitutional and human rights and fundamental rights of every person in the country.
Thank you very much, ma'am. I want to quickly take that question to Matthew as well. Matthew, one of the major challenges that we are facing today is that not so much that COVID-19 discriminates people, but some of the consequences of COVID-19 has created new forms of challenges for the law to handle, including, for example, in places there have been new forms of discrimination, including xenophobia. There has been rise in cases relating to domestic violence. Even child abuse has been reported, including in India and other parts of the world. So the question then is, to what extent law and institutions of law, such as courts, need to more proactively respond to these challenges, particularly on account of the vulnerability that a disease of this magnitude causes?
Thank you, Raj. One of the positives coming out of the COVID-19, along with the technological changes in the court system, if you want to call this a positive for the legal system, is there's been an outpouring of lawyers, other people in the court system really committed, people in the justice system working together. Hopefully that will continue. But on the other hand, we've seen this, we're beginning to see this far more often in the United States, regrettably. There are people who are using COVID as a means to denigrate other people. There's been anti-Asian sentiment that's been stoked on somehow this notion that COVID was created by the Chinese. And as you mentioned, Raj, there's been an increase in the type of crimes, the type of certainly like domestic violence that occurs when people are put in close quarters the way they are and don't have the normal outlets. So lockdowns have certainly been instrumental to preventing the spread, but they've bred their own problems, and one of those has been domestic violence. There have been task force now established in New York with both the court and the bar to be able to address that issue. It's one of the reasons why it's essential that in terms of our family court system, virtual courts, which where people can have can almost immediately contact a judge, have been established to deal with orders of protection. It's absolutely, I think this was said by Gita and Abhishek, that it's, as the court system, our legal system, our systems of justice deal with these issues, they cannot be just focused on business and contracts, et cetera. They have to be focused also on the regular problems that everyday people have. And those problems have been exacerbated in many ways by this unprecedented condition.
Thank you very much, Matthew. We are indeed coming close to the beginning of our Q&A session, and I invite those of you who are watching to send in the questions in the comment section of YouTube. Abhishek, I have a quick question very specifically for you, because I know that you have thought and written about it. There was an article about the Singapore COVID-19 Temporary Measures Act passed in April 2020. Can you briefly tell us about what that act provides for, but more importantly, what kind of specific lessons that it can give for both India and US?
Yeah, again, 30 seconds with your permission, Raj, on the last comment by Judge.
Please.
I think when we must remember, India is planet Earth's most diverse spot. And if the judge has mentioned about New York and US, let me tell you that those catalysts and divisive points are much, much more prevalent in India. And law has a very simple role. While Justice Mittal is absolutely right in the social healing touch of courts, she gave many examples from J&K, there are other examples in Delhi, etc. I don't think courts have always been able to manage the non-social aspect, this aspect which Justice Cooper talked about. And I think the only simple way, wherever the lower courts, the middle courts, or the apex court has failed, is to come down very heavily on all the adjectives you used. And every example of that must be dealt with punitively. One punitive example creates an exemplar, and that's the only way to cut it at the root. And I don't think, sadly, that enough has been done by the courts in those cases, in those spheres. Coming to your specific question, the article I wrote about Singapore, and I'll take just a minute and a half, because I know we are short on time. In India in particular, and I'm sure a lot of other countries, there have been individual reactions. You have about 100 notifications issued by the Ministry of Corporate Affairs, the Ministry of Environment, the Ministry of Home, about so many things. And obviously sometimes knee-jerk reactions to fill a gap, to fill a hole, to do a patchy work of tailoring on a court which is, finding holes here and there to meet the COVID exigency. What Singapore has done in contrast, which by the way has the huge, humongous virtue of certainty, clarity, minimization of litigation, complete lack of ambiguity, and a very nice code in one place. So they have this act passed specifically for COVID, and it starts by saying it includes all contracts, including government contracts, except contracts entered into during the COVID, which means that if you and I contract during COVID, we're doing it with awareness of COVID, and we can't take recourse to the excusing circumstances provided in the Act. It then goes on in the heart of the Act in 4 and 5 sections to give one of the most comprehensive list of excusing circumstances. That list I cannot repeat, it's got 23 items. You have to see it to believe it. All the excusing circumstances available where you A, notify a COVID event, and B, an assessor, the whole structure of assessors, step in to assess that COVID event has caused a material impact on any of those 23 circumstances, which include guarantors, arbitrations, insolvency, force majeure, blah, 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 everything. And then limitation periods are extended. And then it goes on, interestingly, to create sector-specific provisions. So there's a section on construction contracts, section 6. There's a section on tourism-related contracts. So the advantage of all this is the mere codification of this creates a great benefit and a great virtue. But more than that, there is certainty and there is great clarity. And I think it's time, especially countries like, and remember, this is in a feudatory country, much more so in a federal or a quasi-federal system like India, and in a more federal system than US, like US. I think this codification is extremely useful, and it should be, with modifications, a good model for other countries to adopt.
Thank you so much, Abhishek. All right, so we have some 300 plus questions out there. So let's try to pick them up and choose, and I'll ask questions to each one of you. Justice Cooper, there's a question from Bala Jyoti, who's asking about how far virtual hearings are even possible in courts, particularly in slightly remote parts, but also where matters require a lot more of witnesses' presence and things like that. I mean, you mentioned a bit about it, but I think it will require a little bit of elaboration.
Okay, so that, I believe, is one of the questions of the day that we're facing here. No question, there is no question that virtual courts have worked better than I could ever imagine. Really, in 2 weeks, I've gone from not being able to use any of these platforms, et cetera, to actually having a pretty good sense of how it works. But I find that it clearly works in terms of appellate argument. In terms of real trials, that's an open question. First of all, in the United States, where we have a jury system, nobody is having jury trials now, because the whole notion of a jury is being able to have the jurors in a room together at the end of the case and have the ebb and flow and the exchange, which then results in what we believe would be the just verdict. So that's a whole other question. But in terms of bench trials, which we are doing, I have found that it's not at all a suitable substitute, or it may get better. But I think, I'm not even sure how great, even no matter how fine the technology is, it's much more difficult to get the sense of a person, which certainly, so the cases I do, custody cases, I hear a lot of custody cases, we really have to peer, you're supposed to weigh the sincerity of the parents, weigh their special attributes, their commitment, et cetera, like that. It's very difficult to get that viewing somebody simply on a computer screen. So there's a long way to go before virtual will be a perfect substitute, or anywhere near a perfect substitute for actual when it comes to trying cases. Hearing argument, yes. Actual witness testimony, no. It still remains a problem.
Thank you, Matthew, for your candid comments. Madam Justice Geeta Mittal, there is a question from both Jayashree Singh and Shalini. Both of them are asking for you to reflect a bit on the process leading to the categorization of legal services or legal, what courts and lawyers do as essential services, but also the transition to accommodate what kind of procedures need to be put in place for a fully virtual court platforms across India.
I've been giving this a lot of thought and worried about it, especially keeping in view the disparate, the differences all over the country. The first challenge, Raj, I'm again talking in the context of trial courts and continuing from where Matthew has left. Not only is it difficult to assess the demeanor of the witness, but here a lot of the trial courts record evidence in regional languages. For instance, in Jammu and Kashmir, it's in Urdu. In Tamil Nadu, the trial court may be recording it in Tamil. In Bengal, you may be having it in Bengali. So you have to, first of all, identify an ideal, identical structure, and which has to be uniformly in place. Like that is what I think Abhishek Manu pointed out in the beginning, or I think you did, that we need an identical structure for virtual courts all over the country. The second thing that needs is, a lot of procedural reforms in terms of nomenclatures. How do you number an application? What do you call it? How do you number a suit? Do you identify it by the subject content, intellectual property, criminal case, or whatever you have to do? You have to have absolutely uniform procedures all over the country, uniform manner of pagination of file, a very, very integrated and robust digitization process, which hasn't even begun, and you have to first and foremost ensure availability of the basic infrastructure, which Manu Singhvi pointed out. You cannot even visualize how weak the infrastructure is in the remote districts of, I think, almost every state. Delhi is the only place where the district courts are probably almost at par with the high court running, because all the districts, 7 districts, district court complexes are within one city. But in all the states, I'm sure there would be areas where much has to be done. So first of all, it is to identify which is the uniform procedure. As of now, you would be hearing all kinds of debates as to which is an ideal platform. We are not even, available platforms are unable to even cope with the restricted hearing of urgent matters. They are failing. Either the video is going or the audio is going. So we have to build in an identification of what is the ideal platform for doing all these cases before we can get into the virtual court system at the trial court level.
Thank you, ma'am. And we'll come back to you with about the response for essential legal services. Devika, there's a question from Prasenjit Guha, who is the Vice President Legal and Co-Secretary of the Hinduja Group Limited in Mumbai. This question is about something like what I'm sure your firm is facing. International firms are so much dependent upon mobility, travel, people moving from place to place. And suddenly, all of that has stopped. So then the question is, will this lead to a potential, let's say, reduced, interest in the whole internationalization of legal practice? Is it going to create stronger protectionism and focus on domestic legal practice? Is that also a part of your concern?
Let me answer this question in this way, in the context of COVID-19 and what we are seeing, at least in New York, with many firms that have, let's say, offices domestically or internationally, lawyers who are practicing out of their home state because of COVID may have left their home state to go somewhere else. Maybe they moved to their parents' home, which is in another state. And while they may have thought that these lockdown orders are only for 2 weeks, a month, well, it's 3 months, maybe 6 months, but they're still out of state. They're still out of state practicing. This is a lawyer mobility issue in a larger sense. And in the US, we have rules on practice and what is considered authorized practice, what is considered unauthorized practice, right? So you have to be licensed in the state that you are in to practice law. And these rules are pretty much uniform around the country, but there may be some variations. But the ethics rules and the professional responsibility rules are really state by state. So there's an interesting opinion by the DC Court of Appeals on the effect of COVID and unauthorized practice of law. And there's been an emergence around the country of some kind of safe harbor, and this has happened pre-COVID, of course, to provide lawyers with some flexibility in representing their clients outside of their states when they need to be in a state where they are not admitted, but they need to handle a matter in a sort of a temporary and an incidental manner, those being sort of the buzzwords, which would prevent those lawyers who are not licensed in those states but are present there doing something from being held liable for unauthorized practice. So the DC Court of Appeals has taken an interesting approach and said, well, this kind of situation where you may have a home or you may be staying in DC while you may be admitted somewhere else, but you're practicing for some period of time in DC, that'll be considered a form of incidental and temporary practice where the lawyer will not be held for unauthorized practice.
Thank you so much, Devika, for that. There are the number of questions from Titas and Makin and Xenophobia and Jayashri and Shazia. These are all broadly connected to digitization, use of technology, but I'm going to take this question to Abhishek. Abhishek, one of the concerns that are being expressed in the form of questions today is this moment our stronger embracement of technology, but also somehow our acquiescing to give away our civil liberties? There are questions that are being asked about the Arogya Setu app, also the natural tendency for, let's say, compromising a lot of our privacy. So is this the civil liberties concerns? How do we address this?
I do not see any necessary antithesis or contradiction between the two. If you are making the equation between lawyering through technology versus privacy. As far as lawyering through technology is concerned, it is only a question of logistics, capacity, funds, and uniformity. Just as Mittal mentioned, I counted that a writ petition can be described in 14 different ways in 14 different high courts in India. A simple thing like a writ is given a different nomenclature in 14 different ways, so that you cannot have it susceptible to computer analysis for aggregation, for numbering, for analysis, etc. This is just an example. The technology systems between the Supreme Court and the Delhi High Court vary. I don't understand why we cannot have a uniform system instead of each trying to outdo the other. But that's as far as technology is concerned. As far as privacy is concerned, I think there are serious concerns, but they do not necessarily intersect or inhibit virtual lawyering. I don't think that you should bring in, because lawyers or judges who suggest that we should have less of virtual lawyering because of privacy concerns may not be right. That might be more of an excuse. I think one of the valid objections to virtual lawyering is the lack of an open court hearing. And I think there is more merit in that. An open court hearing is one of the greatest safeguards of independent judiciary. But I believe that technology which permits on a first come, first served basis, 100 people, for example, to hear a hearing, those who are interested, will create an open court hearing. After all, even today in physical courts, you can't have unlimited people, hordes descending in a courtroom. So I think you can take care of these things because it is important to marry technology. As far as privacy is concerned, I think the jury is out. Each time a new app comes, and now some of our apps in India have been made compulsory for travel, as and when domestic travel starts. There are serious concerns because nobody knows. There are conflicting reports, but I would tend to agree with the skeptics. I think all of these apps, especially the new ones, and the so-called ethical hackers, two of them have shown the porousness of these apps itself. I think creates a huge doubt. There I would agree, you need a Chinese wall, and without that, compulsion of an app may be when and if tested in court. And remember, we give a lot of leeway to the executive government during COVID, but if and when tested in court, a compulsion to carry an app whose impregnability has not been established would well be a constitutional issue of privacy.
Thank you so much, Abhishek. Matthew, there are several questions that talk about the emergence, or at least the current emergence possibly, of alternative dispute resolution. The question really is, if this is the situation for the foreseeable future or for a longer duration than we probably thought before, is this also a moment when negotiation is the new litigation? As in, more and more disputes that would have otherwise come through court process are increasingly going to go in that route.
So, Raj, it's funny to think that 2 months ago, 3 months ago, the major issues we had in the New York court system, the focus was on moving more cases towards dispute resolution, as well as restructuring the courts. That seems like a lifetime ago. It's hard to imagine that was our concern. Those were our concerns when we're facing now. But I think we must remain committed to alternative dispute resolution, because that is our court system in New York, as Deva could tell you, is overburdened, but nowhere near as burdened as the Indian court system, where your caseloads are immense. I'm sure Gita can go on forever about that. There's actually immense court system, case backlogs and dockets. We need other ways to resolve cases. I find that it's going to be difficult, though, to do that remotely. It's much easier when you have all the people in a room, where you can do shuttle diplomacy, where you can talk one-on-one. That's part of the way that this process works. Can it be done remotely? Yes. I'm sure it can be done even better remotely as we develop different apps that allow you to break off with one group, go back to the other group, but it's going to pose extraordinary challenges. On the other hand, I do find that people are resolving cases now, because they realize once we're back as a court system, we are going to be so backlogged with trials. It is going to be months, if not years, before a trial can take place. And people are recognizing that this is a necessity now to move ahead and resolve the case. And finally, looking optimistically at humankind, people may be saying, with the problems that are going on in the world, my little dispute over my little acre of land, or my dispute over whether I'm entitled to X amount of dollars or not, might not be all that big, major, where life itself is at stake. And hopefully those sentiments might encourage people to try to resolve the disputes rather than hold out, waiting for a court system to reopen.
Thank you very much, Matthew. Well, ma'am, Justice Geeta Mittal, there are lots of questions coming from Jammu and Srinagar. And, there are, we have Neha Sharma and Makhan Kulair, Megha Anand, Vaishnavi, and also Shazia Sheikh. They're asking, one is there are lots of questions focusing on the essential services that you talked about. How do we, make a legal and institutional framework that will ensure that legal services are essential services? And a second set of questions are about how do you empower the legal education scenario? Now, for example, I do consider the Jindal Global Law School and OP Jindal Global University as a privileged institution. We, once the lockdown was announced, we moved the entire education online. Over 5,000 students and 600 faculty members are teaching online. It's happening in a seamless manner. It's quite extraordinary. Even the attendance levels are over 70%. So we have not been affected in that sense. But that may be the clear privilege of the few. What's going on at law schools in your state?
So this is the time. It needs for you to move here as well. But let me answer your question. So far as judicial education is concerned, we have a very vibrant online program going on. We are having a webinar every day. We've had 3. I had Dr. Shetty from Mumbai talk to all the judges on stress management 2 days ago. We had Veena Rally talk about the relevance of mediation for trial court judges yesterday. And we had Bharat Chugh talk on bails, grant of bail and the entire jurisprudence today. And tomorrow we are giving them a holiday. And on Monday and Tuesday, Justice Pradeep Nandajog, Maharashtra Judicial Academy, we're doing a lot of collaborations. And I have Justice Rajesh Bindal of the Chandigarh High Court, who's here, is my J1 in Jammu and Kashmir, also very proactive. And so we have been speaking, we have spoken, and we are joining the Maharashtra Judicial Academy in Justice Pradeep Nandajog's programs on Monday and Tuesday. So that's been our trust. So far as legal education is concerned, I have not been able to intervene at all, other than trying to organize. We did placements in Kashmir 1 year ago when the 8 of the topmost law firms from the country came and interviewed our students. We had to train the children how to write application forms. So Delhi University collaborated and helped us train the children how to do interviews. And we were able to place 50 children in either internship or job placements with the topmost law firms in the country 1 year ago. Unfortunately, a series of things, including COVID, has happened, and we've not been able to complete, though the applications have come in Jammu also for further ahead. I understand that the national law, there's a proposal for starting a national law university in Jammu and Kashmir. They've opened a campus of for a law university in Ladakh, I think, but there is also a move on for starting a national law university on the same styles as same pattern as exists in the rest of the country. And hopefully legal education will also take off in a big way. The children are extremely bright here, I've seen that, and very hardworking, and they will compete well. So Raj, this is an invitation to you to help Jammu and Kashmir as well as Ladakh. Come and do something here.
Thank you so much, ma'am. I deeply appreciate that. And I think we've had some conversations, but should be an opportunity for us to also do something there.
Maybe an off-campus.
Sure, ma'am. Devika, there are several questions that are also expressing concerns about the future of technology and its impact on the legal profession itself. There have been articles written about to what extent artificial intelligence and robotics are going to shape the nature of the legal profession. Are there jobs that are currently being done by lawyers going to be taken over by AI and robotics? And how are firms like yours preparing for that future?
Raj, it's such a great question. Artificial intelligence has been prevalent in legal practice for some time now. Even the use of email to some extent uses that kind of technology. And we don't think about some of those things, but clearly legal research, online legal research has used that technology. But drafting settlement agreements, legal briefs, legal research, jury selection, AI tools are being used increasingly. We have to remember to a large extent, there are a number of different studies done on this and analyses, but this is a form of machine learning as we know it. And clearly the benefits are producing at a lower cost, an efficient service, something that lawyers can use to deliver a product to a client. And there's clearly a concern that that lawyers who are right out of law school, who would be doing that kind of legal research and drafting of initial memos, filling out forms, that they might become redundant. And that is a worry of the legal profession generally. But we also have to keep in mind some really significant limitations that artificial intelligence technology has. And the biggest question is it really reliable? Humans are not perfect. And clearly, artificial intelligence tools that humans create are far from perfect. They lack human intelligence, they lack human judgment and human intervention. Critical thinking capacities are probably missing. Some may say and argue that the ultimate question is no longer how technology fits in with the legal work, but how do humans fit in artificial technology? And tied to this issue of artificial intelligence is really the issue of technology generally for lawyers, and how do they use it, and where are we going to be 5 years from now, 10 years from now, in using legal technology to practice law. And many concerns in our bar associations over the years have been over, are we as lawyers competent enough? And that is built into some of our ethical duties now, by the way. Do we have legal competency as lawyers? Do we understand the technology we're using every day, the apps, the emails, the texts, to deliver the service? Are we being mindful of the confidentiality concerns, the security concerns, information security, all the issues surrounding cybersecurity and privacy? So, I think we have to think about technology and artificial intelligence especially, and sort of think about what the new model is going to be going forward, because we clearly don't want robots to replace us.
Thank you so much, Devika. That was a very comprehensive response. In fact, I want to share with you and the viewers that our university and law school has moved into AI-enabled and remote proctored entrance examinations for admission to all our courses. We recognize that physical examination is not going to be possible for all courses. We have moved into JSAT, which is, we're going to administer it through AI and remote proctoring. The admission to our law school, Jindal Global Law School, is going to be through LSAT India, again, entirely AI-enabled and remote proctored. So there is a lot of innovation that's happening even in higher education. Abhishek, this is a question to you. Kaushik Raja is talking about, this question is about modernizing courts and investment in the justice mechanism, and also investing in technology. And I want to push that question a bit more at a public policy level. Regardless of whichever governments that have come into power, and I'm going to ask you to talk not as a member of parliament, but somebody who has keenly observed the working of the legal system. Is it fair to say that we have not taken our courts in terms of investing a lot more in our courts infrastructure? In some ways, when the government's tendency to build a bridge or a road is a visible improvement of infrastructure, but somehow what courts do and their importance in the justice delivery mechanism is not obviously seen, and hence we have not given enough importance when it comes to actual financial investment in relation to improving the entire legal infrastructure, not just physical, but beyond.
I think you're spot on, Raj. Irrespective of political color, all governments have been complicit in that, right from independence. Fact one, we have had amongst the lowest judges per million population ratio. It has crawled after a lot of stick beating by the Supreme Court over 15, 18 years, from roughly 11 per million to now closer to 20. The minimum ideal would be 33 or 50 per million. Number two fact, we have had a fractional, infinitesimal fraction of the planned expenditure on the judiciary. In fact, the judiciary was not even part of planned expenditure for decades. When it was brought in during our erstwhile planning scheme, the fraction of planned expenditure in judiciary was fractional, very small, less than 1%. Fact number three, post the demise of the Planning Commission, and I know this is a little India-centric for our foreign friends, but this is basically the difference between planned expenditure and non-planned expenditure. Even post that, the amounts spent outside of ad hoc grants to the judiciary is one of the lowest in the world. Fact four, when there are specific grants given, for example, fast-track courts got specific grants, the figures reveal an interesting trend. Large amounts are left unused. These are interesting contradictory stories of the two sides of the same coin. The reason is simple. You don't have a synergical all India plan. So you just give a grant and the state is not ready. Or some of these grants require matching grants. And while the central government is ready to give it, the states are not ready to expend it. Net result is that the power of the purse, which is the one power which the judiciary doesn't have. I guess the judiciary in India is the most powerful in the world, short of making a man into a woman or vice versa. It can do everything. But the second thing it cannot do is the power of the purse. And I think that is where empowerment is important. I think, take for example, COVID issues. We are having cries every day about individual courts not having sufficient employment, manpower, or technology to be able to ramp up this COVID times. Now, these are very small paltry amounts we're talking about. So I think this is somewhere where all governments have failed. And I think it's time the judiciary stood up for itself in a very strong way. And it will take less than 5 years to change the landscape. You have a lot of funds for other activities, but for hardcore infrastructural building in a concerted manner over a 5-year period is what we require.
Thank you very much, Abhishek. Let me go to Matthew. Matthew, there are questions from Chandra, Kanaka, Priya, Anand, and Nakbulla. These are questions that are related to digitization more broadly, but also connects a very important, let's say, a reluctance on the part of traditional institutions to reinvent themselves. Quite remarkably, we learned that breaking 700-year-old tradition, the British Parliament had a Zoom Parliament session on 22nd April. There are countries such as Brazil and Canada and part of European Union, significant interventions are happening in the Parliament as well. We have not had a parliamentary session, and I will get to Abhishek that can we conceive of a Zoom Parliament session or a Microsoft Teams Parliament session in India. But the point I really want to say is that to what extent the reluctance of traditional institutions such as the courts are in many ways currently undermining the effort to promote access to justice.
That's an excellent question. So maybe I'll use as my first virtual webinar, an actual physical exhibit, some physical prop. This is a court case file. These, of course, in it are paper, it's a paper motion. This is what I grew up on. This is what I've been used to. This is what certainly judges, many judges of my age, this is what we rely on. So it's been a major change to be able to go from doing this to what we do now virtually. But in some ways, it's been probably a change that's long been overdue. Many courts and many of my colleagues do exist in a somewhat paperless filing. They have paperless filing parts. Most parts don't. But this has been an impetus to change, so we all get on board. But yet, yes, but there, Raj, I think that your question is well taken. There is probably institutional bias in doing things the way we always did it, because that's somehow how most institutions work, be it legislative or be it judicial. But this crisis has shown that we've had to look for different ways to do things. And even like United States Court, the United States Senate, look at the United States Supreme Court, first time ever, they did argument where it was by phone and the public could listen in, as opposed to having to be in the courtroom and hear the justices, see the justices and hear them take argument. But I think the real question, and I've been thinking about this as I've listened to all my panelists, is what kind of system do we want, as opposed to what can we have? We clearly will have the technology and will have the technology, because it develops at warp speed, to do a very, very virtual court system. But do we want that? The same way with education. Raj, you talked about how all the Jindal students are taking courses online. But once this is over, do we really want that? That's a question. It's a philosophical question. Are there certain things to be gained by having people doing things the more in our traditional way of gathering together in a courthouse or gathering together in a classroom, as opposed to doing it remotely? Big questions. I'm really curious to see how this all plays out. But an answer to the question, the last few words, an answer to the question, all the ways certainly aren't working now. Courts have to get in line with modern ways of doing things, the way other institutions are, in order to meet this crisis. Once the crisis is over, the question becomes, where do we go from there?
Thank you so much, Matthew. Ma'am, this is Geeta Mittal. This question is to you, a little bit drawing upon what we just had with Matthew. You know, the whole challenge of e-courts and fast-track courts, it actually resonates a lot more for a country like India, with 1 billion+ people, vast, geographical situation, huge disparities of income and wealth, and also layers and layers of procedures and processes. Do you think that some of the lessons that we are learning, even though it is part of a crisis, would actually help us to go beyond this crisis? Is this Indian judicial and legal systems opportunity to shape the future? And if it is, what do we need to do?
Raj, we have no choice. This is, I began worrying about post-lockdown the day lockdown was imposed. And I already have an action plan for what to do when lockdown is removed, the restrictions go. For instance, but we can do it because we are a small court. My total sanction strength is 17, which is divided between 2 wings. So I can place the judge in the chamber and have lawyers in the courtroom arguing remotely within the court complex itself, restricting entry only to cases which are being heard. But this is also possible if I do not take up the 200 cases which are on the judge's board. We will have to restrict it to only urgent hearings if we have to go by the norms of social distancing. It's a Herculean effort is needed to ensure that we are able to discharge our complete duties, and we are able to, unbundle all the litigation and all the areas that we have accumulated over the years, plus the cope with the daily filings. The futuristic courts, the designs which I'm looking at, there I'm planning for double the capacity. 1 room for the judge and the staff, 1 room for the litigant and the lawyers to argue from. Similar to vulnerable witness deposition complexes, which we created in Delhi way back in 2012. Witness waiting room, 1 place, judge, the accused, prosecutor, defense lawyer in the court. So, that kind of a scenario you have to build on, but we have to really look into it extremely deeply, especially I was talking about separating lawyers from the courtroom in the context of the constitutional court, the high courts. The trial courts are an entirely different ballgame. We really must think hard as to what we are going to do the trial courts in the context of what Matthew has said. I have visited, Matthew, we call them lockups, the holding area where accused are held when they're waiting to be taken to the court. I knew Judge Fern Fisher in the New York courts, very, very strong on legal aid. And I asked her and I took permission and I visited their lockups. You know what they call them, Raj? They call them tombs. I asked them why they call them the tombs. They all started laughing in Fern's office and her staff. And when I went into the lockup, or the tombs as they called it was actually a tomb, you know. It goes 3 stories underground, and the number of people that are there. So not only in India, but the world over, we really have to maybe sit together and thrash out and evolve an ideal situation of what we are going to do even post lockdown.
Thank you so much, ma'am, for that very candid set of comments. Devika, there are several questions from young lawyers who are also asking about the fact that, as you see today from the side where you are in New York, there are growing calls of economic protectionism, including localization of business. Your president has called for strengthening the American manufacturing sector and also discouraging exports of different kinds. Our prime minister has spoken about self-reliance. So the question is, as you sit as a law firm partner, how do you respond to the business side of it in relation to the prevailing economic and political environment?
Well, firms like ours, we have a variety of different clients. And in New York City, it's an interesting place to be as a lawyer, where there are small businesses, there are mega multi-national corporations, and lawyers are really trying to serve the needs of different clients in different settings who have very, very different circumstances. And there are so many questions that COVID-19 has raised. We discussed some of them today, the issues surrounding material adverse effect clauses, force majeure clauses, business interruption, insurance. That's really a big part of this, and the payroll protection program, the plans for that, the applications for that. Many lawyers are working with clients on those kinds of issues. There are issues surrounding insurance and cyber insurance. These all issues are all related. They're all interconnected in some way. But for the business community, the city has seen a huge hit, clearly, and lawyers in different capacities are trying to sort of grapple with the different laws and regulations that are coming out almost daily, some of which are clarifying earlier requirements and trying their best to advise their clients accordingly. So, it's really a situation where times are changing, and you try to stay on top of these issues in a very careful way, because clients, businesses, and practices depend on it. So these are challenging times.
Thank you so much, Devika. We have over 100 plus questions still unanswered. I'm not going to try all of that. We are slowly coming to the end of the program. Abhishek, this question is from Shabir Ahmad Mir and Sanyam Surana and Surendra Dutt, and several people are asking this question about affordability. I mean, one of the things that is a major concern, even during non-COVID or rather pre-COVID times, and now more, to what extent the legal system is prepared to respond to the access to justice problem, particularly for affordability with regard to lawyers. Now, if you look at American firms, for example, there is a very strong pro bono culture. In the Indian context, barring the benevolence of individual public interest lawyers, it is fair to say that we don't have a well-established culture and practice of pro bono work. How do you think we can address this?
Raj, I'm not entirely sure that we do not have that culture. I would say that probably our institutional mechanisms for that are weaker than they should be. The culture is there in the sense well beyond PILs, because a lot of PILs are public interest oriented. but they've been given a bad name when they've become a publicity interest or personal interest motivated litigation. But at least I think probably a number of 25 to 33% would be a respectable number depending on the court, where good is done or attempted to be done. But even legal aid programs on an individual, the problem is again lack of a national organized uniform grid. But individually courts keep doing. For example, just to give an example of pro bono, take ADR. It's again not organized as in the Californian system where ADR was born or in other parts of USA. But individually courts, a court annexed ADR, annexed to the Delhi High Court, for example, or the Maharashtra, Bombay High Court, etc. Amazing work is done. And it is either done pro bono by a large number of lawyers who act as conciliators, mediators, or it's done at a pittance. The figure is ridiculously small. Similarly, if there was an organized system in different high courts, and certainly the Supreme Court, where every senior advocate, which is the counterpart for our foreign friends of a QC in the UK system, is mandatorily required to do 5 free cases a month. I'm giving a ballpark figure. It could be 3, it could be 10. I don't think any senior counsel worth his name would say no. But again, the institutional mechanism is weak and ad hoc. There are legal aid programs in each court, but they vary. And the problem with legal aid programs is that when you get a legal aid brief, it is becoming synonymous with ill-prepared or poor representation briefs in India. So it's important that it's tied up. There is no reason. I made a proposal to the Bar Council many years ago that 5 mandatory free cases a month should be done by senior counsel. But the marking has to be a system, and I don't think anything worth its salt is going to say no. So I think the culture is there, but it needs, again, organizational backing and a very varied impact. One court will have very good results, the other court will have virtually no results. And that is where we are lacking.
Thank you so much, Abhishek. Matthew, since you work on issues surrounding domestic violence, there are a number of questions, or rather family law related matters. There are a number of questions that are being asked about. Do you see this particular moment has the potential to have a larger number of cases which are arising out of people staying at home and in lockdown situation, intimate partner violence, and other type of such cases? Is there a surge or a possible surge in that?
So I've seen a number of things. One is, yes, a surge in domestic violence, and that people are forced to stay in close proximity. People don't always do well, especially when when there are already tensions being in that situation. I've also had cases where I wanted people to move out, where before the crisis started, I had divorcing spouses living in the same apartment with the children. I made it clear that's just an unacceptable way to be. And now they've been somewhat stuck. It's in static. So it's a static situation. Fortunately, it is somewhat lifting, and then people are doing the right thing and separating. But that is one of the really dire consequences of this situation. People being an increase in domestic violence. At the same token, there's also been many difficulties about access with children. We have what we traditionally call visitation, now called parenting time. That's become more difficult. People either sincerely or otherwise, I don't want their children to travel to see the other parent. We have cases where people were away when this took place, and now they've been separated from the parent for months, for now going on 2 months. What we try to do there is come up with a situation where, an approach where we balance the risks versus the benefits. It's required, it's necessary that children have contact with both parents, both for the children and the parents, but we have to do it in a way that's safe and a way that protects the children. That's been a struggle. I guess the one thing I quipped to my colleagues recently, the marriages are not taking place in New York the way they were because the marriage bureau has been closed down. You can do some remotely, but it's difficult. So the end result is we'll probably have less divorces in in the long run, for at least for a while, since we're not having any marriages. But I think we're all yearning to go back. One thing I guess it might be the last question I have. I think everybody is yearning to go back to a pre-COVID system. There will be significant changes, but a system where we can be more responsive and not just be responsive remotely and virtually.
Thank you very much, Matthew. We have a couple of questions. And ma'am, there's a question for you, Sumit Bhattacharya. He's asking about the same question, but also is there rise in, let's say, POSCO related cases, labor law situation? In some ways, from the standpoint of judiciary, are you seeing certain cases dominating the current discourse?
The answer, surprisingly is no. I've been following it up with the police as well. We've seen registration of a few rape cases, but other than that, the police has not seen a spurt. We've not had a spurt in these cases. Raj, I just want to flag one more point. Lawyers have been in a lot of difficulty. Here in Kashmir, we've had to reach out and the government has given us 1 crore to assist lawyers, and we've received almost 2,500 applications. We're in the process of giving assistance to lawyers because of the COVID-19 and lack of work and clientele issues.
Thank you so much. Thank you so much. I'm going to take one question to Devika. Devika, there is a question about, to what extent legal education is going to be affected by this challenge. As a lawyer practicing there, as you look at it, are there important lessons that legal educators and law schools need to learn when they, get into a post-COVID, preparation and planning, including curriculum reforms?
That's a really great question. And for law students who are in training right now, or looking to embark on this extraordinary profession, what they are experiencing is so important. It's a life-changing opportunity right now. We're talking in this conference about changes that are about to happen. And many panelists have raised the question of, well, what do we want? And here's an opportunity for legal education and for law students who are interacting in that legal education system to really rethink what is legal education for and how are lawyers going to use their skills and their training in the real world. In what capacity? And by that, I don't mean, are you going to be a litigator, or are you going to be a transactional lawyer, or are you going to represent individual clients? But more broadly, in terms of what is, what can you do to make the world a better place? How can you protect your clients more effectively? Where is your passion for justice? But I think that the biggest lesson that we are all learning, whether we are in legal studies right now or in legal practice, is the fact that we all need to be, and we all are at this point, prepared for the unprepared. And we really still don't know what to expect down the road, even though we are planning and strategizing for what is to come. So for a law student and for legal educators right now, the question is really, how do you engage law students to really learn from this crisis, and how are they going to collaborate in times of crisis, and how are they going to be better lawyers, and what do they see themselves to be when they think of them as successful lawyers? What does success really mean to them? As I think a wise person said once, you never want a serious crisis to go to waste. Mm-hmm. And what I mean by that is that it is an opportunity to do things that you thought that you could not do before.
Thank you very much, Devika, for that. Abhishek, there are a very interesting set of questions coming from Sanjay, Swarbani, Sumitra, and also Soumya and Vishu, they probably are asking a question which I think only you are most suited to answer, because you wear the hat of both a lawyer and a parliamentarian. The heart of the question is that this entire migrant crisis and the vulnerability crisis that you're facing in India today, is it time for us to have a comprehensive social security legislation? Because so long as we don't have that, all kinds of piecemeal models, we provide employment here and there, we provide food here and there, we provide food grains here and there, we create some sort of crisis management mechanism as and when they come, but all of them are piecemeal, half-hearted, poorly thought out, and even less effectively implemented. The real thing that we need to do is to bring out a comprehensive social security legislation.
That's a solid question for the additional reason that it thinks long term. It has no relevance to COVID because such a fundamental structural point is something which may be activated because of COVID, but which can't really serve the COVID problem. But as a concept, I would entirely agree. We have talked about it and lamented about it ad nauseum. I think it's time to just get down to implementation without committees and without thinking more about it. We have to start with the acknowledgement, which is obvious but is frequently forgotten, that 90% and a minimum of 85% of the Indian labor force is unorganized. So you have the bulk of it, all the trade unions, all the factory workers, all the unionization, and possibly 85% of the labor laws cater to those 15%. This is a reality which makes social security, forget social security, that's too sophisticated a term. Simple enumeration and inventorization of a list of names. Today, for example, we did not have proper data about the number of migrants. So an individual state roughly estimated that from UP and Bihar, about 50 lakh people would be coming from Maharashtra and Tamil Nadu. Now, we don't even have a record, leave aside social security. I think this is a large topic, but the short answer to your question is, we have to start yesterday. A, documentation, and B, the fear of it is that after you document, you have to pay them a dole. Nobody's suggesting that the dole and the card have to be linked, but a proper documentation so that in times of crisis, you can reach it to them. You know, the irony was that an excellent program we had, either Aadhaar or Jan Dhan, which is done through an Aadhaar card, which is the last mile connectivity for direct benefit transfers. Even those could not take off because you don't have it in a proper documented form for the migrant category. A migrant category is, of course, a subset, a small subset of the unorganized sector. But you have to start by enumeration, documentation, and then, you know, it is easy to link up. And for the next disaster, God forbid, whenever it happens, at least the start now would provide a proper, immunity and a scheme.
Thank you, Abhishek. So we come to the end of the program, and so I'm going to ask one last question to all the panelists, and then we will wind up. Although there are, as I said, another 75 questions. All right, so let me start with Matthew, and the question is: there are lots of students of law who are watching this program. They are also facing the anxiety and the uncertainty of the future, including the graduating batch of students across law schools in India and around the world. What would you tell to them, each one of you? What would you tell to them to give them hope, give them aspiration, and in many ways to make them recognize that the future is strong for the legal profession? What are your words of wisdom, Matthew?
Well, I don't know if they're words of wisdom, but let me say, Raj, anxiety is certainly the word of the time. I had trouble sleeping last night, not so much because what I was going to be able to say today, but would I be able to actually use the Zoom capabilities, and would I be able to participate in this? Could I get it to work? Fortunately, my wife's better at this and she was able to put me online. But what I would say to the students is, we have been through really bad times before, both as countries, as societies, and as lawyers and judges. Following 9/11, the talk was maybe we'll never recover in New York. Following the Great Recession, in 2008, it looked like the people were making most dire predictions about the legal profession, that we never recover. You know what? We did recover. And the same way we recovered from those catastrophes, we'll recover from this. The law will be different. Courts will be different. Our systems of justice may be different, but I'm hoping, similar to what I think everybody on this panel has said, it could be for the better. And so I can, with all sincerity, sound a note of optimism. It's bad now, it looks bleak, but there will be ample opportunity to prosper as lawyers and to do good for the world. So
Thank you so much, Matthew. Devika.
Raj, I would echo Matthew's words and say that that we should all stay very positive. And I'm reminded of what Benjamin Franklin said, instead of cursing the darkness, light a candle.
Thank you very much, Devika. That was very inspiring indeed. Abhishek.
Raj, I don't want to sound pompous or sermonizing. Young people are brighter than the best. But I think the general lessons of life are more important from COVID than really the legal sector. The first, and this is obviously a personal wish list, varies from person to person. The first for me is the awareness of minimalism. Not that you have to be minimalistic, but that you can be minimalistic to a far larger extent than you ever thought before COVID. Two, to realize that the core things which matter are pretty few in number. Three, not to have recidivism. I think everybody forgets a crisis very far too quickly. And there is bound to be a normalcy. My problem is the reverse. In the new normal, let's not forget the crisis and the lessons it has taught us. And ultimately, I think the new skills we learned during COVID, not only in lawyering, but new skills everywhere. I think these four things would make us better people if we did not forget, because it's going to end sometime. And I think we're going to be back to our bad old ways very soon.
Thank you very much, Abhishek, for that. Ma'am, you have the last word.
About what can I say? I think all my predecessors, speakers, all the speakers before me have said it all. But I would like to remind everybody that the sun always rises. After every sunset, there is always a sunrise. So do what Abhishek Manu Singhvi, I'm so used to calling him Manu, has said. Be patient in a big, big way. Keep working hard, and there will be no dearth of opportunities for any of us. Thank you.
Well, thank you very much, Abhishek and Devika and Matthew and Justice Mittal. This has been a fascinating program. I want to express my deepest appreciation for the wonderful, panelists and speakers who have accepted our invitation to be part of it. This has been an extraordinary exercise for us also personally. I must tell all our guests today that, we've done so many webinars, but never before it has happened so perfectly. And it clearly is because of your commitment and dedication to what we are doing today. So I want to thank our IT staff as well. I want to thank all the viewers. As I said, we had over 4,000 registrations and over 300 questions, and it's been a fantastic exercise. For all the viewers, I want to leave one thought in this, is that as we look at the future, we do expect to overcome this crisis. Collectively, as a part of a consciousness in humanity, we will overcome. As we speak, there are over 100 efforts that are taking place around the world to find a vaccine, to find a cure. And I know for sure that we will overcome. But during this crisis, for all of us who are watching this program and for all of us who are speaking in it, we must say that we are privileged. We are privileged at so many levels, and this is also an opportunity for us to appreciate our privileges and to invoke our deeper sense of responsibility as lawyers, as law students, as law professors, and indeed as judges. With that, I'm signing off. It has been a pleasure engaging with all of you on behalf of OP Jindal Global University and Jindal Global Law School, and also our partner Live Law. I would like to thank all of your presence. We will come back just in a few days on 20th Wednesday, we will be hosting the Law University Vice Chancellor's Colloquium on the future of legal education during and after COVID. We will have Professor Sudhir Krishnasamy, the Vice Chancellor of National Law School of India, University Bangalore, Professor Vijay Kumar, the Vice Chancellor of National Law School in Bhopal, Professor Kamla Shankar, and former Vice Chancellor, National Law School, Trichy, Professor Poonam Saxena, Vice Chancellor, National Law School in Bhopal, and Professor Ranbir Singh, Vice Chancellor, National Law University, Delhi, and I will be moderating that panel. I look forward to seeing all of you. Thank you very much, and have a good evening to all of you. Thank you. And good morning, and have a nice day in New York.
May I propose
Thank
four
you,
cheers?
Raj.
Sorry, please, Abhishek, please.
Just may I propose 4 cheers from 4 people for an excellent moderator?
Thank you.
Yeah.
Raj.
Yeah.
Thank you so
Thank you.
much. Such a
Thank you.
pleasure.